Hello, good evening, everyone. Today I have been asked to speak on the topic Probation of Offenders Act. In order to get an idea of the problems which are sometimes faced while dealing with the provisions of this Act, I have chosen some questions which are frequently asked by the judicial officers pertaining to the Probation of Offenders Act. So I think if we discuss these questions, it will give us a clear idea of the Act and some of the questions, some of the problems which are faced by the judicial officers. So starting with the set questions, one of the questions which is asked is which of the two provisions is to be applied? Whether we go in for Probation of Offenders Act or we apply Section 360 CRPC. So is there any law which tells us that which provision is to be applied when? So the answer to this question is that the states where the Probation of Offenders Act has been brought into force, the applicability of the provisions of Section 360 and 361 CRPC in that area would stand excluded and cannot be resorted to. There are various judgments of the Supreme Court on this point. And if you are interested in noting them down, I can tell you a few. One of the earliest judgments is Daljit Singh versus State of Punjab, 2006, Volume 6, Supreme Court Cases, page 159. It was followed by Channi versus State of Uttar Pradesh. Channi, CHHANNI, Channi versus State of Uttar Pradesh, 2006, Volume 5, SCC, page 396. Thereafter, we have Gulzar versus State of MP, 2007, Volume 1, SCC, 619. Then we have Ramesh versus Raghu, 2008, Volume 4, SCC, page 588. And some more judgments are also there. We also have one contrary judgment on this point, where the Supreme Court has, in the year 2019, it said that both 360 and 360 CRPC as well as Probation of Offenders Act, they are in existence and they are, and either of them can be applied. But however, keeping you the earlier judgments of Supreme Court repeatedly, not one, many of them, which have laid down clearly that once the PO Act comes into operation, then 360 CRPC will not apply. So any contrary judgment, it has to be by a larger bench. All these said judgments are by 2 judges benches of the Supreme Court. So we will apply the aforesaid law as laid down in these various judgments. And moreover, these judgments have also clearly explained, clearly refer to the statutory provision, Section 19 of the Probation of Offenders Act. It clearly stipulates that once the Probation of Offenders Act comes into operation in a particular area, then Section 360 will not apply. So all these judgments have referred to the said statute only the judgment which I which I was referring to, the contrary judgment, it doesn't refer to the section 19. So that is the law as it stands, as to which provision is to be applied. All right, then we go on to the question of age. Supposing we have a person 50 years of 50 years old, and he's a previous convict also. Can he be released on probation of good conduct? The answer is yes, he can be. Under probation of under Section 4 Probation of Offenders Act, he can be released on probation of good, because the provisions of Probation of Offenders Act are much more liberal than Section 360. There is no such limitation. In Section 360, we have the division of the cases as per age. People who are the accused who are below 21 years and those who are above 21 years, different yardsticks are provided. The accused who are above 21 years, for them offenses punishable up to 7 years only. Only those are covered by the provisions of Section 360. But this is not the case under Probation of Offenders Act. So there is no such limitation as far as age is concerned, and there is also no such bar of previous conviction. Section 360 clearly talks of the provision being applicable only in those cases where there is no previous conviction. But there is no such bar under PO Act. Even a person who is previous convicted, he can be admitted to probation. So that is the difference. Let's move on to the next question. Talking of age, do we have anything special under the Probation of Offenders Act for any particular age group? The answer is yes, we have Section 6 of the Probation of Offenders Act, and it lays down that any person who is below 21 years of age and he is entitled for being released on probation of good conduct, if the court is not inclined to release him on probation, any person who is below 21 years of age and the court is not inclined to release him on probation, then it has to take two steps, mandatory steps. First of all, it has to call for a report of the probation officer. The said report has to be considered by the court. And if the benefit of probation is not being extended, you have to record special reasons why the benefit of Probation of Offenders Act is not being extended in this case. So if you are dealing with a person who is below 21 years of age at the time when you are passing this sentence, you have to take these two steps. So be careful when you must call for a report of the probation officer. And if in case you are declining the relief, you have to record special reasons for doing that. All right, then we have another question. If X committed offense under Section 325 IPC, fourth question. I think if you are seeing it on your screen, if X committed offense under Section 325 IPC when he was 20 years old, and he was held guilty by the magistrate when he was 25 years old. In this case, can the magistrate decline benefit of probation to the accused without calling for any report from probation officer and without recording special reasons? So what the questioner wants to know is as to what the age factor. We have section 6, which says that any person below 21 years of age, for that person, you have to release him on probation or you have to record special reasons. So what does section 6 say? Section 6 talks of the age of 21 years, but not at the time of the offense. It is at the time when the court is convicting him, at the time of conviction. That is the difference. Though we, as far as other laws are concerned, there we heavily rely upon the date when the offense was committed. What was the age of the person when the offense was committed? But here, as far as section 6 is concerned, it has been clearly laid down as far back as 19. It was 1963, a very famous case, Ramji Misr versus State of Bihar. Ramji Misr versus State of Bihar. The citation is JIR 1963 Supreme Court, page 1088. It is a four judges bench judgment, where this was explained by the Supreme Court as that section 6, the age of 21 is to be seen at on the date of conviction and not on the date of offense. So as far as this question is concerned, that here when the offense was committed by the person, he was only 20 years of age, but when he's being convicted, he's 25 years of age. So he is above 21 years, and therefore the rigors, the restrictions, the limitations of section referred to in section 6 will not apply. So the court, while declining the relief of probation to this person, is not mandatorily required to call for a report from the probation officer and to record special reasons. It is only in those cases where the accused is, where the convict is below 21 at the time of conviction, that the said restrictions apply. Okay, then we move on to the next question, which is pertaining to compensation. And the Code of Magistrate First Class Ludhiana convicts X under section 324 IPC and releases him on probation of good conduct under section 360 CRPC. So that will be more a theoretical proposition now, because now 360 CRPC will not be applicable. Now you will apply the provisions of Probation of Offenders Act. But as far as this question is concerned, that if a person has been released on probation under section 360 CRPC, can the court grant him compensation? Can the court grant compensation to the victims? Sorry. Can the court grant compensation to the victim under section 357 CRPC? The answer is no, he cannot. Section 357 applies. The very opening line of the section 357 is that where a person has been sentenced to fine or imprisonment, he can be awarded compensation under section 357. But probation, when you leave a person on probation, you are not passing any sentence or punishment against him. So when you are not passing a sentence, then section 357 doesn't apply. So you cannot pay compensation if you have released a person on probation under section 360. But if you have released a person on probation under section 4 of the Probation of Offenders Act, you can grant him compensation, because there is a specific provision under section 5 of the Probation of Offenders Act, which allows you to do so. Section 357 will not permit you to award compensation in that case, but Section 5 Probation of Offenders Act does permits you to do so. So you can do that. All right, next. Where a person, is there any other restriction under the Probation of Offenders Act? Any category of persons to which the benefit of probation will not be applicable? Yes, there is one category to which the benefit of probation cannot be extended. And they are cases where life imprisonment or capital punishment is prescribed. So any offense where the maximum punishment prescribed is life imprisonment or capital punishment, in those offenses, the benefit of probation cannot be extended. So this was a question where the question was regarding Section 326, whether where a person is being convicted under Section 326 IPC, can he be released on probation or good conduct? No, he cannot be, because under Section 326 IPC, the punishment prescribed is the maximum punishment prescribed is life imprisonment. So the benefit of Probation of Offenders Act cannot be extended to these offenses. Next, we have the question whether this benefit can be extended to a case of under PC Act Section 13(2). 13(2) का केस है, 13(2) PC Act के अंदर अगर कोई कन्विक्शन होती है तो उसको क्या प्रोबेशन पे छोड़ा जा सकता है? This was question number 7. The answer to this is again no, he cannot be. And the reason is that Probation of Offenders Act itself contains a specific provision, Section 18, which states that the provisions of Probation of Offenders Act will not apply to offenses under Section. Earlier it was Section 5, now it is Section 13(2), under the provisions of Section 13(2) of the PC Act, Prevention of Corruption Act. So a person who is being convicted under Section 13(2), he cannot be released on probation. All right. Another question which is very frequently asked is regarding the cases where a sentence of minimum punishment is prescribed. Say, for example, as in question number 8, we have the case of we have this offense under Excise Act. Supposing a person is convicted under Excise Act 1914, which carries a minimum sentence of imprisonment of 6 months. Can that person be released on probation? So this question was answered by the Supreme Court in a very famous case. That was Ishar Das, ISHAR, Ishar Das versus State of Punjab. AIR 1972 Supreme Court, page 1295. And again, a full bench of our Honorable High Court, Joginder Singh versus State of Punjab, 1980 Criminal Law Journal, page 1218, 1218. This is a full bench judgment. And we also have a very recent case of Supreme Court, which is Lakhvir Singh versus State of Punjab. 2021, Volume 2, Supreme Court Cases, page 763. It was explained by the Honorable Supreme Court in the case of Ishal Das that Probation of Offenders Act is applicable even to those cases, even to those acts where a minimum sentence, minimum punishment is prescribed, minimum sentence is prescribed. The Supreme Court explaining the aforesaid proposition. First of all, the reasons which were given by the Supreme Court. Number one, that section 4 Probation of Offenders Act, it contains a non-obstante clause which clearly states that notwithstanding anything inconsistent in any other law. So there is a non-obstante clause. Secondly, we have referred to the case of Ramji Misr in the earlier proposition discussed by us, AIA 1963 Supreme Court. In that case, the 4 judges bench had clarified that the provisions of Probation of Offenders Act being beneficial provisions, a very liberal interpretation has to be made of the provisions of the said Act. And thirdly, most important factor which was considered by the Supreme Court was that section 19 of the Probation of Offenders Act says that the provisions of the said Probation of Offenders Act will not be applicable to a few exceptions were laid down. And one of the exceptions was that it will not apply to cases where a minimum sentence is prescribed under section 13(2) PC Act. So it has excluded only one specific act, that is PC Act, that the only one provision containing minimum sentence, that is section 13(2) of PC Act. There were various other acts, various other provisions where a minimum sentence was provided. Excise Act was one of them. It was also there, but it does not refer to any of those acts. So it is excluding only one specific act, one specific provision, that it will not apply in that case, thereby meaning that it has, there is no such bar applicable to the other acts which contain such provision for minimum sentence. So on that reasoning, the Shahbaz case, it was said that Probation of Offenders Act is applicable even to those cases where a minimum sentence is prescribed, It will apply to those cases also. But there is an exception. We are coming to that. We are coming to that also. We are referring to some other cases also, as in the case of next question is regarding Dowry Act, section 4 of Dowry Act, which again has a provision for minimum sentence of 6 months. There was a judgment of the Supreme Court, Muhammad Hashim versus State of Uttar Pradesh. Muhammad Hashim versus State of Uttar Pradesh. It is of year 2016, in which they said that the provision of Probation of Offenders Act would apply in this case also, but they gave a different reasoning. They said because Section 4 of Dowry Prohibition Act no doubt says that a minimum sentence of 6 months is there, but it further contains a proviso which says that the court may, for adequate and special reasons to be mentioned in the judgment, impose a sentence of imprisonment for a term of less than 6 months. So the Supreme Court said that so we can say that there is no such, that it is not one of those cases where a minimum sentence is prescribed, because the courts have been given a discretion for reducing the punishment. They can impose a lesser sentence than 6 months. So it is not one of those cases where a minimum sentence is prescribed, and so Probation of Offenders Act can be applied to this case. However, in this case, the judgment passed in the case of Ishar Das was not produced before the Supreme Court, so there is no reference to the said court case. Otherwise, the matter would have been simpler, as it has been already been explained in the case of Ishar Das, that why the provisions of Probation of Offenders Act are applicable even to these cases where minimum sentences are provided. All right, let's move on to the next question. Somebody has referred to a case under Defense of India Act. Defense of India Act. That was the case. The title of the case is Superintendent Central Excise versus Bahubali. 1979 2 Supreme Court cases, page 279. Under Defense of India Act, again, there is a rule 126, Rule 126. If somebody is convicted under Rule 126, it carries a minimum sentence. So in this case, the case of Bahubali, the Supreme Court said that Probation of Offenders Act will not apply. In this case, the benefit of probation cannot be given to a conviction under Defense of India Act, which again has a minimum sentence of 6 months. So what is the distinguishing feature of this case? Why is it different from the case of Ishar Das? The difference lies in Section 43 of the. There are two reasons. The Defense of India Act, it is an act passed in year 1962. The Probation of Offenders Act was passed in year 1958. So this act, Defense of India Act, has come later on. When we are interpreting any provision and we want to see the intention of the legislature, then the date on which the act came into force is very important. So this act, Defense of India Act, has come later on. It has come later on, and it contains a clause. It contains a Section 43 which says that notwithstanding anything contained in any other act, the provisions of this act will prevail. So now the intention of the legislature is clear. They know that Probation of Offenders Act is already there, which says that it will apply to all cases, even where minimum sentences prescribed, it will apply to those cases also. Then subsequently, the legislature passes another act where they say, notwithstanding anything to the contrary contained in any other law, these provisions will provide. So the intention of legislature is clear, that they want that the Probation of Offenders Act would stand excluded as far as this act is concerned. So this is how this provision was interpreted by the Supreme Court in the case of Bahubali, and that was the right interpretation. We have various acts which have come subsequent to the 1958 Act of Probation of Offenders Act. Now, because the law is clear that even where the minimum sentence is prescribed, Probation of Offenders Act will apply. So all those acts have now a specific provision in those acts which say that Probation of Offenders Act will not apply to this case, will not apply to this act. So let's go on to the next question, which arises from a recent judgment. The recent case of Lakhvir Singh versus State of Punjab. Lakhvir Singh versus State of Punjab. This citation is 2021, Volume 2 SCC, page 763. This judgment has again reiterated the law which was laid down in the case of Ishwar Das. They have again explained that merely because some offense carries a minimum sentence doesn't mean that the provisions of Probation of Offenders Act will not apply unless there is a specific bar in the said act, and the said act should be subsequent to the passing of the 1958 Act. They have also referred to the case of Bahubali for explaining the said proposition. They refer to the case of Bahubali, but in which cases Probation of Offenders Act will not apply to offenses carrying a minimum sentence. This judgment is again interesting for another reason also. Here the question of pertaining to Section 6 was also raised. The accused was 20 years of age at the time of offense, but when the case was decided, he had already exceeded the age of 21. So the Supreme Court said that keeping view the judgment of passed in the case of Ram Misra versus State of Bihar, Probation of Offenders Act cannot be extended to such persons. The provision of Section 6 of Probation of Offenders Act will not apply. So that law has been reiterated in this case again. This was it. The accused in this case, he had committed some offenses under IPC. The offenses were of robbery, etc. And he was convicted for an offense where a minimum sentence of 7 years was provided. Minimum sentence of 7 years under Section 397 IPC. Now the appeal in this case was pending before the Supreme Court, and the accused filed an application that he has already compromised with the victim and the offense stands compounded, and so he should be released. The victim had also appeared before the Supreme Court and had accepted the said statement, and he agreed that a compromise has taken place, and that he has no objection if the convicts are released in this case. However, the Supreme Court said that the offenses in question were not compoundable, and so no question of compounding arises in these cases. As far as, of course, as already discussed earlier by us. They said that merely because minimum sentence is prescribed, that of course doesn't bar the applicability of, will not bar the applicability of Probation of Offenders Act for offences under the Indian Penal Code. The Indian Penal Code came into existence much prior to 1958. And the Probation of Offenders Act has a non-obstante clause. So it will apply even to offences where a minimum sentence is prescribed. It could apply, but as far as compounding is concerned, that cannot be permitted. So they applied the provisions of Probation of Offenders Act in this case, taking into consideration that the parties have compromised, and also taking into consideration that the convict had already undergone half of the sentence. He had already undergone 50% of the sentence, and he had also compromised with the victim in question. The victim had no objection to his release. So considering all those factors, the benefit of Probation of Offenders Act was extended to the accused, and they were released on probation. So that was the case of Lakbir Singh versus State of Punjab. All right, we have another question which is pertaining to NDPS Act. Supposing a person is convicted for possession of 500 grams of poppy husk, can he be released on probation? The answer is no, because NDPS Act has a specific provision, Section 33, which states that the benefit of Probation of Offenders Act will not apply to cases under NDPS Act unless the person is below 18 years of age, or the offence in question falls under Section 26 or 27, which are minor offences. So as far as possession of poppy husk is concerned, the bar of Section 33 will apply, and the person cannot be released on probation or good conduct. All right, then we have another question regarding road accidents. A person supposing he is convicted under Section 304A IPC, can he be released on probation or good conduct? Again, we have to refer to the judgment of Supreme Court in the case of Dalbir Singh versus State of Haryana. Dalbir Singh versus State of Haryana. It's year 2000, volume 5, SCC, page 82. In the said judgment, it has been clearly laid down by the Supreme Court that by releasing a person on probation, you have to take into consideration the circumstances of the case. And while considering the circumstances of the case, the nature of offence is the most crucial factor. Offences, road accidents fall in the category of such offences where there should be no scope for releasing a person on probation. Keeping in view the rates at which the said roadside accidents are taking place, and the negligence of the drivers, a strong deterrence is required, and so the courts should not release such persons on probation. This is how this is what has been laid down by the Supreme Court in the fourth judgment. Now we come to the last question. A person was convicted under Section 408 IPC and released on probation. But in departmental proceedings, his services were terminated. So if this person files a civil suit and claims the benefit of Section 12 of the Probation of Offenders Act, which says that the person dealt with under Section 4 of the Probation of Offenders Act shall not suffer disqualification, if any, attached to a conviction under any law, notwithstanding anything contained in any other law. So Section 12, the question is regarding Section 12 of the Act, which says that once a person has been released on probation of good conduct, that then any disqualification, he will not suffer any disqualification which is attached to the conviction. This question had come up before the Supreme Court in the case of Harichand versus Director of School Education, AIR 1998 Supreme Court, page 788. And again, another case, Union of India versus Bakshi Ram. This case is of year 1990. In both these cases, the Supreme Court has explained that as far as Section 12 is concerned, it only applies to those cases where the conviction is attached, where the disqualification is attached to the conviction. Say in a case where a law says that once a person is convicted, he cannot fight, he cannot stand for an election. So there is a disqualification attached to the conviction itself. That disqualification will not apply. But as far as departmental proceedings are concerned, they are separate proceedings. They have nothing to do with the with the conviction of the person. A person is being proceedings are being taken against him, and departmental proceedings are being taken against him for misconduct or some other provision under the civil services law. And that provision is totally different. It does not fall in the category of Section 12, which says that attached to a conviction. It is not attached to conviction. It is a separate proceeding. So his services can be terminated. So that is how this question was answered. So these are some of the questions which were asked by the judicial officers, and we have tried to answer them. So let's hope that the things will be simpler and there are no such complications. If you have any complication pertaining to Probation of Offenders Act, you can dial me on my phone number or send an email, and I would answer any query which you have pertaining to the Probation of Offenders Act. So, okay, and thank you very much for today's session.